In this paper, Richard criticizes several very different patent cases, which broadly speaking are patent weakening, but he focuses most specifically on the oil states versus green energy case, which is the only constitutional case that he mentions, and which recently held that a patent can be repealed outside of an Article 3 court. So the broad stroke of his argument is familiar to folks in the IP space. It goes something like patents are property, and if patents are property, then they should be strongly and highly protected. And to put my cards on the table, I'm not a huge fan of using this broad argument to get at really specific questions about the scope of IP rights. But especially here, to be doing patent originalism, I think we need to make sure to root that argument in the constitutional text and context. So let's do some patent originalism with the oil states case specifically and patent rights generally in mind. So as Richard does, the obvious place to start is the Progress Clause. He argues that if patents are understood as having an origin in natural rights, the inclusion of the right to make patents would include the concept that administrative repeal, such as that which was at issue at oil states, wouldn't be part of having a patent or couldn't be part of having a patent. I don't see too much evidence that the founding public not only held this natural rights or common law view of patent law, but crucially also thought that that idea was bound up in the Progress Clause itself. But I do think it's interesting to talk about what originalism can say about the clause and draw out where ideas of natural or common law rights might pop in. So looking at the Progress Clause as a whole, we're in the classic case where there's not as much textual evidence or discussion as we might ideally want from an originalist perspective. There's no record at the Philadelphia Convention of any debate concerning the Progress Clause, but given the statutory language in state IP clauses at the time, referring to arts and sciences and to earlier proposed drafts of the clause, it does look like the omission of the term fine arts was intentional, which I think is just interesting. Richard's colleague Barton Beebe, in his own scholarship, finds this omission really strange because there was a belief at the time, not just in scientific progress, but also in aesthetic progress. But he guesses that this happened because of a parallel belief at the time that in early America, that the fine arts were at best useless and at worst corrupting of your virtue and religious faith. So there you have it. There is, as Richard notes, a brief discussion of the Progress Clause in Federalist 43, which presents an interpretive puzzle that I think is interesting to bring out, even though it doesn't appear in Richard's paper. So Madison wrote of the Progress Clause, "The utility of this power will scarcely be questioned. The copyright of authors has been solemnly adjudged in Great Britain to be a right of the common law. The right to useful invention seems with equal reason to belong to the inventors." So Madison's reference to copyright being a common law right is almost certainly a reference to the 1769 British case Miller versus Taylor, which did hold that copyright was a common law right. But it was reversed 5 years later in the 1774 case Donaldson versus Beckett. So Madison's error here, so that Madison writes this after Donaldson, but doesn't know about it. And his error raises the super interesting question about how patents and copyrights were understood, given that the English interpretation, which held after that, that copyright was not a common law right, hadn't kind of fully come over to the United States. So it is possible that there might be a greater belief that IP was a common law right in America because of this failure of transmission of information. So moving past the clause, given the lack of direct interpretations of the Progress Clause, it might also be interesting to look to early American patent practice to understand patent rights. So there are two early statutory patent regimes. The first one from April 1790 to February 1793, patent applications were evaluated, again, by the Attorney General, Secretary of War, and the Secretary of State. The documentary record is not complete, but it seems like less than half of patent applications were granted. There aren't explanations for the rejections, but historian Dumas Malone believes that some of them were because Jefferson disliked frivolous and unworkable devices. But as has been stated in many places, this was just too onerous a system. So actually from 1793 to 1836, patents were a straight up registration system. And the Patent Office did not have the power to deny patents on the merits, period. So you had a lot of bad patents in this time period. They were duplicative, they were contradictory. And so you had lots of cases to repeal patents. Statutorily, they could be repealed for being obtained surreptitiously or by false suggestion, but in practice, cases were often brought just saying this patent's not novel. And so the false suggestion is that it's novel. There's also interesting evidence about the kind of public meaning, perhaps, of the patent clause by looking at what inventors thought was patentable, what they registered for. This is discussed at length in Michael Rich's article, America's First Patents. Obviously, the inventors themselves are hardly neutral sources, but it's still interesting and indicative of something. We might also find it interesting to note, in terms of early practice, that until 1903 in copyright cases, works were often deemed not copyrightable because they did not sufficiently promote progress, right? And so all of these cases for the first like 110-ish years of the Republic ascribed a limiting power to the preambulatory phrase, or limiting elements to the preambulatory phrase, which is just not the law today. So this early practice suggests an originalist might believe that there is a constitutional requirement that, individual patents actually promote the useful arts. I want to turn to the oil states case specifically with a few originalist notes about the relationship between English and American patent law. So in this case, both the majority and the dissent, written by Thomas and Gorsuch, so you have originalists on both sides, tried to use English patent practice to support their positions. But the relationship between English and American patent law is messier than in many common law legal areas in this time period. So unlike where American states would sometimes just usually adopt British common law directly for certain areas of law, America's constitutional and statutory patent law did not adopt English law, and from the beginning in many ways diverged from English law. So this leads historian and law professor and my colleague, Christopher Beecham, to warn in his article, Repealing Patents, of, quote, the dangers of engaging in an Anglo-centric originalism in the context of patents specifically. Not only, he writes, is it inapposite to look solely at English practice, but it's also problematic to read the early American law as though it merely replicated the system of royal patents. But it's more complicated than that, right? Despite the actual reality that American patent law differed from English patent law on paper, in practice, it sometimes didn't, because early American judges and lawyers often made just straight up mistakes applying English patent law that diverged from American patent law. The reasons for this are that it was much easier to access published British decisions. American decisions weren't reported. There were no reported patent decisions until 1804, and they were hard to find. There was no American treaties on patent law until 1810, and that one also cited English law. And when I say straight up mistakes, I mean, they were just straight up mistakes. So methods were patentable under American law and not in English law. But there are many 19th century American cases that find patents that say something is not patentable because it was a method, and they're specifically looking at and citing English law. So if we really want to zero in on the question of repeal, though, I think we do have to look more to Article 3 than the Progress Clause, and to this divergence between the idea that, and I'm borrowing from Caleb Nelson's article on adjudication in the political branches here, the idea that core private rights have to be extinguished in Article 3 courts, privileges do not have to be. Nelson's clear that, land is an Article 3 thing, welfare benefits are a privilege. Where patents and copyrights go is less obvious from this dichotomy. But I do think that the balance seems stronger on the side that patents are more of a privilege. Early case law indicates that patents were not thought of as common law rights. We see this language repeatedly. When the question of common law copyright came directly before the Supreme Court in 1834 in the case Wheaton v. Peters, the court rejected the notion that copyright protection existed under the common law. Now, this is several decades after the founding, but kind of close enough that I think it's still relevant. And Wheaton v. Peters also spoke clearly about patents in dicta, saying, quote, there's that common law no property in them. There's not even a legal right entitled to protection. So, wrapping this up. This is all a light surface skim of patents in an originalist context, and I don't think at this level anything I've said is decisive. But it leads me to my major comment about this paper, which is I think the paper shouldn't be called Patent Originalism. I think a better title would be Patent Rights in Historical Perspective. I think doing originalism is something different than what's going on in this paper. You know, we want to be big tent originalists, but I think it's still useful to distinguish between scholarship that does originalism and that doesn't. And when we do originalism, we're usually trying to ask a question about constitutional meaning with a reference specifically to how it would be understood by a particular population at a particular time. And although this paper draws from a lot of historical sources, it doesn't always take that step of connecting the historical legal concepts with evidence of how the founding public or founding era lawyers understood them. And without that connection, I think we're doing legal history, but we may not be doing originalism. So admittedly, Richard says this at the beginning of the paper in the first few sentences. He says he's engaging only in a quasi-originalist inquiry. And given that particular perspective, I would just put the paper on surer footing for satisfying its own goals by taking the notion of originalism out of the title and out of the text and replacing it with history. Thank you.
Thanks, Christina. Richard, you're outside the tent. You have 2 or 3 minutes to come on back inside the tent.
Oh, thank you. Let me just mention a couple of things. One is there are all sorts of complications about copyrights and patents, which in fact have somewhat different situations. So it's very difficult to sort of draw inferences from one area to the other area. Even today, they are on completely different practices. And then the question is exactly, do we want, I guess our major question is, do we treat these things as common law rights or not as common law rights? I think the answer is that to the extent that they involve use and disposition, these are common law rights. As for anything else, to the extent that they involve exclusivity, they are not common law rights. They are created by statute. But it doesn't follow because they're created by statute that they're not property rights when the statute itself makes it rather explicit that they're talking about grants. It's also very clear that people are talking about exclusive rights. They're not talking about monopolies in the technical sense. The entire law of patents is designed in such a way that you can put something up as a device in order to achieve a particular end, but when you have to give notice as to how you're doing it in verification, you're actually planting the seed so that a competitor could come in and start to deal with it. Then, of course, there is the question about how does this relate to originalism? And I think it's really important to understand that this paper is in some sense designed to both validate and to show the limitations associated with originalism. So if you had an originalism approach of the sort, for example, that Larry talked about, it'd be pretty clear that you could not, under the Constitution, give any protection to literary works. What has happened is something which I've called in other work a prescriptive constitution, which is we start to develop consistent practices which are in flat contradiction to what the text says. And these then, by virtue of the passage of time, then become official doctrine in the United States, and you overturn them at their peril. Huge portions of the Constitution have that particular characteristic. There is no federal jurisdiction in diversity over corporations. That's all a fiction, and so on down the line. The Electoral College is still a deliberative body. It's not that today. We do these things and we can't change it. So I think what's really important here is to talk about patent originalism. Its uses and limitations may be a better term. But I would think that this is something which there's a great deal of effort to try and use early practice to figure out what's going on. And it's also a great deal of effort to use standard interpretive methods to fill in the gaps in these clauses by analogizing these grants to other areas. So I disagree with Christina on what the law says in these cases. It's clearly a separation of powers issue. Nobody at the time would have thought that a patent was a public right in the sense that a customs dispute was some kind of a public right. They were regarded as grants, and under separation of powers, once a grant is issued, it cannot be revoked by the party that gave it. It could be only revoked for cause in a judicial proceeding. That was the unambiguous rule with respect to land. And if you go through the McCormick case in particular, and then all the cases that it cites, they basically treat the same rules as applying in both of these particular areas. So I think in effect that you can say, I think that you don't have a common law right to exclusivity. That's part of the game. But once you get a statutory right that combines with your common law rights, I think that they're both regarded as vested. And therefore the oil rates case, which tries to basically say that you could revoke this thing at will, is a real distortion of the historical cases. As I said in the paper I wrote on oil states, every case that Justice Thomas cites is miscited in some fairly fundamental way. So I'll stop at that.